This is Bajaj Allianz Life. Life Goal Talks.
Hi everyone, I'm Dheeraj Sehgal and I welcome you all to Life Goals Talks. To start with, let me introduce myself. I work as a Chief Distribution Officer for institutional business at Bajaj Allianz Life Insurance. And I've got now close to 2.5 decades of experience spanning across financial services and pharma. And I'm passionate about building new business models and strategies through which we can help people in our country solve their problems related to investments, savings, and financial goals. And today, we are looking to find solutions for one of the most pressing concerns that people face, particularly in the later years, that's around legacy. And the question that we're going to delve into is, why is it important to write your will? We all love our families, and we want to ensure their safety and security. And all of us were deeply concerned about our family's futures when COVID was at its peak. There's one definitive way of ensuring that your family and loved ones are safe, even in the future, in case something unfortunate happens to you, and they're left to fend for themselves. But that solution is writing your own will. And in some cases where the assets are widely dispersed, also doing estate planning. In today's podcast, we are joined by Jatin Popat. Jatin is the founder and CEO of WillJini, which is a Mumbai-based firm that provides succession services. Jatin has over 35 years of experience in the world of finance. In this episode of Life Goals Talk, we'll be discussing the crucial matter of writing a will with Jatin. So Jatin, thank you so much for taking your time out and welcome to Life Goal Talks podcast.
Hi, Dheeraj. Great to be here. And thank you for having me here at this podcast.
So Jatin, I want to start off with the subject straight away. Writing your will. This is a bit of a sensitive subject, isn't it? People are reluctant to talk about this, but it is also an important one at that. The idea that in case somebody has to, or somebody's family has to face an untoward, unplanned situation, we must leave behind an inheritance, which is not in a mess that our kids or wife or family need to run around resolving while mourning and grieving. So what are the main points that you feel one needs to keep in mind regarding will writing and estate planning?
Yes, Dheeraj, you are right. That's a very sensitive subject and also important. Though I mean to say that we all been working hard for creating wealth and for securing our family for happiness and comfort. But say, for example, someone just passed off suddenly from the earth and the family go to off balance. So that could be a bigger problem because each and every individual has some loose ends in their life and some incomplete or unfinished matters. And here, the legalities comes in picture quickly. Though that means the spouse and children are really don't know much of your wealth or assets, and they don't have a financial or little literacy around what is to be done. Now, that is already a problem for them emotionally when they are facing some death in the family, which is the leader of the family. And then they have to be also calm for the next step, what is to be done. And that is also creating a lot of problems that they see together when they start discussing about inheritance. So when they have already a lot of investments in wealth created by a leader of the family in properties and banks accounts and insurance and demate, but people don't know where it is kept and what to be done next. So that way, it takes a lot of time for them to at least figure out. Even family, when they know that okay, this wealth is there, they come to amicable solution that let us distribute within ourselves because they don't know whom to distribute. So they then approach societies, banks, insurance companies to claim, and then when they claim, they go to claim it when there is no will. There are situations with nomination, no nomination, or there is some completely single asset owned by the family, and then these banks or ready-made people, they will ask succession certificate. And the struggle start again. What is a succession certificate? Whom to approach? How to get this succession certificate? So first is to get a legal professional who is good in knowledge and cost effective. So in a nutshell, this particular extent of getting to a succession certificate process itself will take another couple of months. And then to get a succession certificate again, 6 to 8 months times and then couple of lakhs. So overall, these hassles and doing lot many things can be curtailed by writing a will. So will is just a plain paper declaration. It's a declaration. So legally it is called a declaration by a person. So basically this is just a declaration on a plain paper. So the asset that he can cover there, it could be physical asset, it could be financial asset like shares and mutual fund, business assets. If somebody is doing a business, which type of business they are holding, digital assets, and also intangible asset like trademarks or some domain name and all. So these are the details they can mention in the will. And also they mentioned whom they want to give after their the demise.
Thanks. That's a very simplistic and interesting way of looking at the will writing from a common man's perspective. Jatin, thank you so much for that. You said that it's a form of care that one feels and a way of leaving a legacy. But the fact also is that not everyone in India writes a will. It's perhaps a function of the reality that till a few years back in our country, most of the savings were held in a very traditional way. We had gold, we had some bit of cash in the family, and the fixed or immobile assets like land and houses. But even then, that was a luxury for many. So we've never really had a culture or a society-wide procedure about will writing. Do you think it is a correct or accurate assessment of the situation?
Very true, Dheeraj, that this country is on faith and customs and traditions so far. A lot of weight is given other than the law also. So we all know that despite there is a law in India about succession or inheritance since 1925, almost a century ago, but still so many people in last 100 years or maybe millions people have inherited the wealth to the family on a customary basis. We had a system where the head of the family will take over the asset if something happens to the male or female, and then there is no question coming out from the children or any relative. So that's a customary tradition we all were following, right? But also there are equal number of cases around on similar matter. Almost 1/3 of the total legal cases in India are related to inheritance since many years. So this is a story where inheritance was taken based on the customs, not on as per the Indian laws. And also there are so many disputes which has to be faced by the family. But you may agree with me that today wealth is becoming more powerful than the relations. The earlier period we had the family bonding and those concepts which is very tightly being followed by all the families. But times are changing, and today even taking something on like a life insurance policy, the family will say that who is taking over the money after that. So these are the typical thing. So the law is becoming now prevalent than the custom. So when law is more prevalent than the earlier times, then we need to know what is the law. And recently, in last 3-4 years, as you mentioned, due to COVID, the numbers have gone 10 times than the previous one, because the will is now being prepared and the law point, and people are not very keen to follow those customs where everything was given to the head of the family.
Mhm. So as per the prevailing laws of our country, what happens to an individual's assets if somebody died without writing a will or without proper estate planning? How do these assets or whatever wealth the person is leaving, how does that get distributed or managed?
So no, the immediate things what comes in the mind of the family, that what the assets are, where it is, and what is the names in the account, whether joint name is there, whether nominee is there. So first of all, that is something, as I mentioned, the treasure hunt start for the family to find which are the things are there and who are the nominees or joint account holder. Now the nominee is, we all know that most of the cases nominee is just a custodian, and everything is to be given by the nominee to the legal heir as per the law or as per the will. So that is something again coming up to the family to answer that what is the law, who is the nominee, whether he can take it or not. So that type of question also props up on all the family. As you know that in 2015, even the insurance law has changed and introduced beneficial nominee concept. The things are again going to the legal professional again from the family that who should own it. So after those exercise is over, where the wealth is, what is nominee, then they approach to the institutions for they asking them, can you transfer it to the nominee or the family? So if there is a nominee, they will immediately transfer to the nominee, but the nominee will have to give it to the legal heirs, as I mentioned. If at all there is no nominee or no joint account holder, the asset will be kept it idle for some time, and these authorities, which could be banks, which could be locker, which could be a demat authority, they will ask the family to submit a succession certificate. So the succession certificate is also a lengthy process and a good amount of expenses there. And if at all everybody is amicably agree, then only the succession certificate process is smoother, can be completed in 6 to 8 months time. But if somebody object those process, everything goes to the wild turn and the things go for the many years. Today more than 50,000 crores of worth of funds is lying with the government, including the banks and other authorities, because bank accounts are not claimed or not being taken. Policies, insurance policies not taken. Provident fund are not claimed. Fixed deposit are lying unclaimed.
I'm glad that our government and regulations are stepping in to protect the interest of the family, which is survived by the person who does not leave a will behind. You mentioned about 50,000 crores lying in banks, which are unclaimed. I'm sure you would agree that the amount is many, many times more than this, but hopefully, will writing will gain more awareness and people will start using this more judiciously. And Jatin, I also heard about this new thing called asset information sheet. Do you think this is the first step for creating a will or a plan to create a will? And also tell us what are the main steps in this process of creating a will?
Right, Dheeraj. So this asset information list is nothing but you're trying to prepare a list of all your assets, which could be the physical asset, which could be your business asset, which could be your financial assets, which could be your intellectual property assets. So all these things, if you put it in a piece of paper or you keep it somewhere for the information of your family, it is good no practice that you go on changing whenever those things are getting changed. However, if you prepare a will, obviously on that particular day, all those lists comes into the piece of paper, which is legal paper, which is called a will. So just mentioning those things in the will help the family as on that date. That will can be written on plain paper. There is no stamp paper required. It can be signed by a person in front of two witnesses, and that becomes a legal will in India, which can be accepted in all the court of law. Now there are a few things that one can also add in this will, where isn't a facility that one can add an executor of a will. So executor is a person who is actually will take care of distribution correctly. So the person who is executor can be from the family or can be outside a neutral person, so that he gets a legal role that to how to distribute, because there could be more than one beneficiary in a will. So to family, they don't fight or they don't have if they don't have any knowledge, it is better to have an executor, which is not mandatory. After will writing, if one has to do registration, it is okay, it is optional. One cannot say that all the will need to be registered. It is not mandatory. If someone want to add the government as another witness, then they can do a registration of a will at the nearest sub-register office. There is no government cost to be paid, except the local person who helps you in registration, that professional fees they may take.
Thanks, Jatin, for the detailed response. You mentioned or you described the steps which need to be taken for writing will in a very detailed and simplistic manner. Person can write a will on his own, has to be mandatorily written. Digital will is not permissible in India. People can take help of an expert like WillJini to write the wills, etc. But you know that if there's an individual who's planning for succession or writing will today, the plans might change tomorrow, or the person might change his or her mind tomorrow. And this is one important topic that I want you to clarify to us. That if writing a will once is good enough, or if somebody has to review it, is there an opportunity of changing your will? And in your expert opinion, should one change a will at all or not?
Dheeraj. So life cycle is totally uncertain and difficult to predict. So whatever planning that we do as on today. What is coming up, we don't know. So say, for example, if I write my will today, it is better to review every year, just like your medical insurance or your life insurance. Similarly, one can just go through the will again once a year to see whether any bigger changes there in the asset base, or any wishes, or the family has any change in anybody has added or deleted or something like that. So those review can happen every year, and maybe 3 years, 5 years, if those changes are major, then one can do a fresh will. Normally, the will, whichever is written, has the blanket clause about the residual asset or future asset. So even if someone don't write a will in life, it can cover legally. But there will be a lot of confusion for any new asset which is born and to be given indifferently. So it's better to write a new will.
And every fresh will, in case somebody opts to write, has to be registered again. Is that correct?
Registration is, we mentioned, it is not mandatory. So if somebody has already registered a will earlier, it will be prudent to do all the registration of a will of the future will also, because then there is a same continuity, though it is not mandatory. So even if first will is registered, the subsequent will is not registered, it is not so mandatory legally. But it is prudent to avoid any undue misunderstanding or dispute. One can continue to follow same pattern. If registration is done, then they can again do registration of a fresh will.
I think that's very important. Thank you so much. Jatin, what about people who have severe disability? For example, somebody slides into a coma, and there have been instances where some people are affected by these conditions for years and they take a very long time to recover. And unfortunately, some of them are not able to recover as well. So is there a provision of will or any kind of estate planning for such eventualities as well?
Any weakness in the mind or fitness where it affects your thinking abilities or capacities. Those are the people who are not allowed to write a will. It's an illegal. So for those type of cases, even one has to wait for the recovery. If they recover well, when the doctor says, yes, I can now give a certificate, they are mentally fit to write a will, then they should go for it. In some of the cases, the disabilities are not continuous one. Sometimes they are good, sometimes they are not. So during the process, when they are good, they can sit with the doctor with a certificate and they can sign a will. And the doctor certificate can be used as to attach along with the will so that it is proved that at particular point in time that person was good to sign a will. So that is the law situation here. Also, we have seen that many a time the people have the joint ownership or those type of things. So in those situations, even asset using of those people are also important. Somebody is in say hospital in coma and hospital bills are going in a few lakhs rupees and there is nobody to pay. So if there is a joint account holder within the family, they can withdraw it for time being. But if there is no joint account or anything, normally the court will issue a guardianship order to take care of those bills of a person who is holding the wealth. There are people who are also writing springing financial durable power of attorney. So there are two type of power of attorney people write sometimes. That in case something happens, the will is out of question during those times. But even to operate those wealth, they need somebody to be there when they are also though they are living in this world, but they are not being able to operate their assets. So people can think of along with the will, they can also write a power of attorney to one of the family member that in case something happens where they are medically unfit or they can operate the assets, the family person can operate the account. There are new concept like springing financial durable power of attorney, which is there in the developed countries far more used than India.
Thanks. Thank you so much. Jatin, we all are aware that the awareness about will writing, although it's been in existence for many decades, as you just shared with us, but the awareness about this particular important step of life about will writing is very, very low. While the law and procedures have existed for a long time, but for most of the people who don't live in the big cities, they don't seem to have enough knowledge about will writing. And we can clearly see from the number of land disputes and the property dispute cases which continue to be seen in the courts, especially in the cities which are in tier 2 and tier 3 categories. In your experience, I'm asking it for the benefit of these people. In your experience, what are the most common mistakes which you feel people make while drawing up a will?
Right. Yeah, plenty of mistakes people are making because of the awareness is low. And sometimes they try to do a shortcut. They go to some people who doesn't have enough knowledge. Sometimes they do themselves. So all these situations are there where people feel that will writing is simpler. I can do it. Yes, surely one can do. But there are mistakes then which obviously nobody can help. This will is to be used only when somebody dies. So few of the example I can give here from our past experience where a lot of litigation is happening in the court of law. People, when they write a will, they are very sometimes very vague in their language. They are not very clear what they are talking about the asset or the distributions. There could be a contradictory statement they make in the will. Somewhere they say everything will go to my spouse, and another way they will say this particular FD account will go to my daughter and all. So those type of things are there, which which people don't know what risk they are taking. Those type of things can again very difficult to solve within the family. And there could be issues around. Also, there are people who just don't care about the mental condition. Somebody, they start thinking about will of the parent when they are at a very late stage because parent has not written will, but they have the asset. So when the parents are at a very old age, they are not in the thinking capabilities. So without any doctor certificate or any medical situation to be recognized, they make a will without no mental soundness. So that can be again a very wrong thing people are doing. People are also trying to make witnesses which are very close relatives. Say, for example, if I give in my will, I give everything to my spouse, and then again I make the spouse's brother or sister as a witness. So those type of things can be avoided. Witness need to be independent. They should be a distant relative. There can be colleagues, there can be neighbors, there can be friends, but there cannot be close to the beneficiary or the beneficiary themselves. So these are again mistakes.
Thanks for that detailed understanding. I'm sure it will help all our listeners who are in the places where they don't really know much about all the things that they need to take care of while drafting a will. Jatin, life insurance plays a very significant role in a will. All of us who buy life insurance, we know that at the time of unforeseen demise of the policyholder, the proceeds of the policy, they form a significant part of the legacy which is left by the primary earning member of the family. And we've all seen in many movies and stories that how people try to take advantage of life insurance proceeds. Can you please explain to our listeners what is the role as per you which life insurance has in this important step of writing of a will?
Dheeraj, I think, yeah, you're right in saying that life insurance is really a big asset for the family if at all something happens to a breadwinner. We have seen people are taking life insurance maybe at the age of 25, 30, whenever they start earning. And then, so at the age of even 30, people are recognizing that there could be a need in the family of the money, and there could be a scenario where death can occur. So these two situations are already been recognized by a person at the young age of say 30. But when writing a will, there are so many arguments that I'm not going to die tomorrow. Why I should write a will? These things are really difficult it's a contradictory for each individual who are arguing this type of thing. Insurance claims, as you mentioned rightly, it's the largest for anybody's life where they took really today everything is going in a life insurance. Term insurance plans are very well issued by all the insurance companies in a very low cost premium. So those wealth is actually can be almost 50% of the overall health of the family. And if it is planned well, that those wealth can be claimed by the family member to whom it is to be given. That is something one has to recognize via will or a nomination. Now there are the will is a primary or ultimate place where you can mention about the beneficiary of your assets, including insurance policy. However, in 2015, this government has amended the law of insurance, and they've introduced a thing like a beneficial nominee. So that type of concept is already being used by quite a few insurance companies for giving the claims to the beneficial owner and explaining to the families and all. However, there are few contradictory case laws against, but nomination making in the insurance policy and insurance companies giving those assets to nominee, it is something a very big relief to the family, because the largest chunk of those wealth are being given to the family member immediately by the insurance company, which can be a good relief at the right time. So later on, maybe if the person has a will or not, that can be separately they have to dealt with. However, writing a will and mentioning the beneficiary for the nominee for the insurance policy is very important. One cannot just depend on nomination given in insurance policy because that could be again a dispute within the family member. So I would say that even there is a nomination concept for the insurance policy, even there is a beneficial nomination concept introduced by the law. However, there are some contradictory case laws. So it is good to write a will with a very small effort and a couple of thousand rupees, and give the family a good relief of what is available, whom to give, and there is a legal paper where even government will support. So these are the few thoughts that I wanted to share.
Thank you so much for that detailed talk, Jatin. We really appreciate and sincerely hope that our listeners find it useful and consider will drafting as an immediate priority, so that they can leave a legacy and a peaceful succession planning can be done. Thank you so much for your time. We really appreciate this.
Thank you so much, Dheeraj. Thank you, Bajaj Allianz team. Thank you so much.
The views expressed by the speaker in the podcast is not to be construed as investment advice, and listeners are suggested to seek independent financial advice before making any investment decisions. For more details on risk factors, terms and conditions, please read the sales brochure available on www.bajajallianz.com carefully before concluding a sale.